Hi students, you are welcome to Angel Health Academy. Topic for the day is legal aspects of records and reports. Legal aspects of records and reports. In the examination point of view, I would like to talk about or select an important topic from the previous university question paper, that is legal aspects of records and reports. So let us talk about what are the legal important or key legal aspects of both records and reports. I have already uploaded a video about differentiate between records and report, as it was one of the important question in the university previous question paper, as differentiate between records and reports. So if you have not watched that particular video, I will give to the card. You can watch that video and you can continue with this video. So introduction. Records are the accurate and detailed information of the care and other health related services provided to the individual, family and community. So as you know, the records are the accurate and detailed information of the care which has been rendered to any patient or individual or family or to the community, or any healthcare services we have been implemented to the individual, family and community is called records. So records are the accurate and detailed information of the care and other health services provided to the individual, family and community. Then in case of reports, reports are either oral or written exchange of information. So reports are the oral or written exchange of information on account of certain events, certain services, certain activities, set activities carried out. So it is a written or oral exchange of information on account of certain events given, or it has to be presented to someone, like health worker has to give monthly report to the medical officer. So presented to someone, or shared between the caregivers, that is between the health team members, like night report, day report, etc. So shared between the caregivers or health team members in a number of ways, in number of situations, in a number of occasions. So reports are oral or written exchange of information on account of certain events given or presented to someone, shared between the caregivers or health team members in a number of ways. So this is the meaning of both records and reports. Thus, records and reports play a crucial role in various fields, not only in the healthcare setting, but also in the business organization or in the government sectors. So records and reports play a crucial or significant role in various fields, including business, healthcare and government sector. As record and report are the legal document, as you know that we consider both records and report are legal document. It helps in legal procedures. So records and reports are the legal document. There are several legal aspects or implications that need to be considered while recording and reporting. So those who are handling the records and reports, they have to consider the legal aspects while recording and reporting, as it is a legal document. These legal aspects make sure that the organization comply with the relevant laws and regulation. The current laws and regulation in relation to recording and reporting are abiding, are following, or flexible with that understanding and doing. So comply with the relevant laws and regulation. At the same time, they protect the sensitive information of the employees or the personal information of the person, and thus the organization maintain the integrity of their documents, integrity of their all documents in the various departments, or records and reports in the various departments. Thus, it is important to understand the legal aspects associated with the records and reports to ensure the compliance with the current or relevant laws and regulations. So thus, it is very important to understand the legal aspects of records and reports to ensure or make sure the compliance with the or follow or abide the current, that is relevant suited laws and regulations. Next is the legal aspects of records and reports. So some important or key legal considerations. There are 8 important legal consideration or key legal consideration. They are, first one is data protection and privacy laws. Data protection and privacy laws or act. Second one is retention and destruction of both records and reports. Retention and destruction. Third one is confidentiality and non-disclosure of reports and records. That is confidentiality and non-disclosure. Fourth one is accuracy and integrity of records and reports. Fifth is legal holds and litigation. Sixth one is compliance reporting or recording. Compliance in reporting and recording. Seventh one is electronic records and e-discovery. In relation to electronic records. Eighth one is others. It includes medico-legal cases. So legal implications, legal consideration in relation to various medico-legal cases. So let us explain in detail about these 8 legal aspects of records and reports. First one is data protection and privacy law. So every country has their own data protection and privacy act or privacy laws. So those who are handling that records and reports, they have to abide this data protection and privacy laws. So the organizations must comply with the data protection and privacy laws, such as, for example, General Data Protection and Regulation, that is GDPR in the European Union, or the California Consumer Privacy Act, that is CCPA in the United States. So here there is 2 examples. One is General Data Protection Regulation, that is GDPR in the European Union or region, and the California Consumer Privacy Act, that is CCPA in the United States. So every country has their own data protection and privacy laws or act. The people who handle the records and reports or organization has to abide or follow or must comply with this act. So this act or these laws govern or control the various collection, storage and processing of personal data of the organization. And of course, this organization required to obtain the consent to get this personal data, that is collection, storage and processing of the personal data. So to obtain consent, then they have to implement the security measures. So they have to protect this data or the documents. So implement the security measures and provide the individual, those who give the personal data, with certain rights, that is maintaining the confidentiality of their personal data. Individual with certain rights regarding their data. So recently Indian government or Indian Parliament also passed an act, that is the Digital Personal Data Protection, that is the DPDP Act, that is in the early August 2023. So all the documents or records and reports handling in our country has to be abide or comply with the Digital Personal Data Protection, that is DPDP Act 2023. So this new act, okay, that is Digital Personal Data Protection DPDP Act 2023 is the first cross-sectoral act or law on the personal data protection in India. So that means in our country, those who are handling the records and reports, they have to follow or abide or comply with the Digital Personal Data Protection DPDP Act 2023. The second key legal aspect is retention and destruction of records and reports. Retention and destruction. So the retention period of certain or specific records that is mandated by the law or act. So act says certain records has to be kept for particular period of time. That means the different types of records have a specific retention period that is mandated by the law or by the act. So every organization must ensure that or make sure that the records or their documents are retained for a required duration of period, and after that it is properly destroyed when no longer the documents are needed. So organization must ensure that records are retained for the particular period of time, that is the retention period, and after that it has to be properly destroyed when those documents are no longer needed. When those documents are no longer needed for the organization. Then failure to comply with the retention period and destruction of those documents or destruction requirements can result in legal consequences such as fines and penalties in the court. So if the organization fails to comply with the retention of the documents and that destruction requirements, then that may result in legal consequences such as fines and certain penalties according to the act or according to the law. That is about the legal aspects in relation to retention and destruction. The third legal consideration is confidentiality and non-disclosure of the records and reports, confidentiality and non-disclosure. So maintaining the confidentiality and not disclosing the particular information to the public or outsider. So records often contain sensitive and confidential information or personal information such as personal data, trade secrets, organization secret, business secrets, proprietary information, so business information, etc. So records often contain sensitive and confidential information. So always record may have a sensitive and confidential or personal information. So organization should have a legal obligation to protect this particular information and prevent unauthorized access or disclosure of this particular information to third persons or other public. So organization have a legal obligation to protect this information, especially personal informations, or that has to be maintained confidential, and at the same time the organization has to prevent the unauthorized access of these particular documents, records and reports, or the disclosure of this information of that particular records and reports. So it is the legal obligation of the organization. So of course there is an act that protect the confidentiality and non-disclosure of the information of the various records and reports as through non-disclosure agreements, that is NDAs, non-disclosure agreements. So non-disclosure agreements may be used to legally bind the individuals or organization to maintain the confidentiality of their documentations, both the records and reports. So that is about the legal practice in relation to the confidentiality and non-disclosure of the information of the records and reports or documents of any organization or healthcare settings or government documents. The fourth legal practice is legal holds and litigation. Legal hold and litigations. So if there is any legal proceedings or legal procedures in the company or to the organization, so in such a case, so in the event of legal proceedings, the organization has to be or they may be required to preserve the particular or relevant records and reports for the period of time until this legal proceedings comes to end. So in the event of legal proceedings, an organization may be required to preserve, to keep for a long period, okay, until the legal proceedings are complete. So preserve the relevant records and reports. This is known as a legal hold or litigation hold of the records and reports. So as records and reports are the legal document, if there is any legal proceedings, the organization has to keep or preserve that particular or relevant records and reports for the period until that legal proceedings get over. So keeping the records for a period of legal proceeding is known as a legal hold or litigation hold. Then if the company or organization is failure to, or healthcare agency is failure to comply with the legal hold, that can result in a severe consequences, that is legal consequences such as sanctions. Sanctions are nothing but it is penalties. So they have to pay certain set of penalties or any adverse judgment against the particular organization. So they have to compensate with the fine and penalty for failure of legal hold or litigation hold. So this is about the legal practice in relation to legal hold and litigation. The next fifth legal practice is accuracy and integrity. Accuracy, maintaining the record accurate and maintaining integrity. Of course, the records and reports must be accurate. Always it must be accurate, it must be complete, and it must be reliable. Any falsifying or tampering, destroying with the records can lead to legal and ethical problem or ethical issues. So any falsifying, any fraudness in relation to records and reports, or any destroying of the records and reports, that is called tampering with the records, that all can lead to legal and ethical issues. Thus, organization always should implement certain set controls and certain legal procedures to ensure the integrity of their records or documents, such as like audit trails, version control, access restrictions, etc. So without permission of the concerned authority, they shouldn't give the access permission to other person to go through the records and the reports of the particular department. So organization should implement control and procedures to ensure the integrity of their records through audit trials, that is step-by-step examination of the various records and reports, periodical examination of the records and reports, that is called audit trials. Then version control, that is put the documents under the control of the particular department. Then access restriction, restrict the entry to avail the information by the different persons or other than the departmental employees, etc. So this is about the legal practices in relation to accuracy and integrity. Then fifth is the compliance reporting. So fifth legal practice in relation to records and reports is the compliance reporting. Some industries or organizations have specific reporting requirements based on their document. So some industries have specific reporting requirements such as financial institutions reporting suspicious transaction to the regulatory authorities. So that is mandatory. They have to report any suspicious transactions or information to the controlling authorities or regulatory authorities. So periodically the organization or financial institution, they have to provide their information, that is records and reports to the particular regulatory bodies or regulatory authorities. Because of that, organization must comply with these reporting obligations to prevent the legal and regulatory violations. So otherwise that organization may be in trouble with the legal proceedings. So organization must comply with these reporting obligations to prevent the legal and regulatory violations. Otherwise it may become the regulatory or legal violations. So organization has to abide the rules and regulations according to the particular act. Thus, it is important for all the organization to consult the legal professionals. So, organization can consult the legal professionals or they can have a legal advisor and stay updated all the relevant laws and regulations in relation to records and reports or documentation to ensure the compliance with the legal aspects of both the records and the reports or documents of the particular organization. So, it is important for every organization to consult a legal professional or to have a legal advisor and update their knowledge on relevant laws and regulations or rules and regulations or the act in relation to records and reports to ensure or to make sure the compliance with the legal aspects of records and reports or documents of that particular organization. Then seventh one is electronic records and e-discovery. So the seventh legal practice include electronic records and e-discovery. As you know, nowadays everybody is following use of various electronic records in the organization. So with the increasing use of electronic records, organization has to be or they must comply with the current laws, relevant laws in relation to or related to electronic record management and e-discovery. So all the organization, they have to abide the current law. They have to comply with the current law and regulation in relation to electronic records. So these laws, that is laws related to electronic records and e-discovery, govern the or control the storage of the electronic records, retrieval of the electronic records and disclosure of the information of the electronic records in legal proceedings. So the organization can be protect themselves from the legal proceeding by following the or comply with the laws that are related to electronic records and e-discovery. So these laws govern the storage, retrieval and disclosure of various information, that is electronic record information in legal proceedings. So this is about the legal practice in relation to electronic records and e-discovery. So last is others. The eighth legal practice is others. That includes medico-legal cases, that is MLC cases occurs in the hospital settings or healthcare agency settings. So medico-legal cases is nothing but, or MLC is nothing but any case of injury or any ailment or disease where some criminality is involved is called MLC, that is medico-legal cases. So medico-legal case means any case of injury or trauma or any case of ailment problems where some criminality is involved is called MLC. So the type of the patients or type of the clients categorized under medico-legal cases include, that is RTA, road traffic accident, fight injuries. So injury by having fight with the people, and suicidal tendency or suicide, homicide, assault, burns, any type of poisoning or rape victims, etc. all comes under medico-legal cases. There are many legal practices for the MLC cases or maintaining the MLC record. Especially, first we have to obtain the complete and accurate history of the MLC cases. So, take complete or accurate, in-depth and in-detailed history of the MLC cases. Second is inform the police officer or the constable on duty or the chief medical officer related to the MLC cases. Third is all the MLC cases patient's case sheet has to be written in the or written with the red ink, that is on the right hand top corner, that is MLC cases. Then do not give any information, any statement about the patient's condition to other people other than the doctors. Only the information has to be given the particular consultant or the physician or the doctor. That means do not give or share any information or statement about the MLC patients to other people. Then while discharge, when discharge, inform the duty police or constable or chief medical officer in relation to his discharge, MLC discharge. And in some cases, MLC patient can be absconded from the hospital or the health centers. So if MLC patient abscond from the hospital, in such a situation, inform immediately to the CMO or the treating doctor regarding his escape from the hospital. That is, if MLC patient abscond, inform immediately to the CMO or treating doctor. Then no MLC patient can go for LAMA. LAMA is nothing but left against medical advice. So usually patient can get discharge himself under LAMA, that is left against medical advice. So they can take their own decision. But MLC patient cannot go for LAMA. They have to follow the strict policies of the hospital for the discharge and other procedures. So like that, there are many other legal practices in relation to MLC records as to be maintained by the person or the healthcare personnel by taking care and maintaining the records and reports of the MLC cases. So this is about the legal practice of records and reports. So far we have discussed an important topic that is legal practices of records and reports. That is a previous question paper solved or in the examination point of view. And hope this video really benefits in your studies and exams. And if you feel it is really worth and beneficial, please like, share and subscribe my channel. So stay tuned with the Angel Health Academy for the next an important academic video. Thank you.